do not, on the basis of fairness and unfairness, justness and unjustness, morality and immorality. Whether you know the law or you do not, you are part of the law, because the law is made for you and you must know the law. Thus we bring you the legal hour. Actus nemini facit injuria. The act of the law does no one wrong, but uphold justice. One of the most famous Latin legal presumptions. Hello and welcome to the long-awaited program that you have been waiting for all this while, which is the Legal Hour, which is live from the Freetown Television Network, Channel 35, with me, Abubakar Maram. The Legal Hour is a show that lucidly educates the minds of viewers out there about legal notions like, do you know your civic rights and what makes you become criminally liable? Ideas like, what are your political rights, and if these rights are violated, what will you do? Legal Hour is not only there to perhaps educate the common man, but it's also there to see how best it enhances the legal concept of even lawyers, judges, politicians, and other government officials. And this is our first episode, and I want to welcome you for being part of this particular wonderful show going on right now. And for today's edition, our topic will be criminal responsibility. And due to that, I have a wonderful legal who is from Legal Aid Board called Mr. Victor Tutu Rogers, who will be our guest for today's episode. Welcome to the program Legal Hour.
Thank you very much.
Yeah. And before we start our discussions, which will be on criminal responsibility, we have gotten different perspectives, different ideas, and several questions on what makes you become criminally liable. What are the limits? And we have this different perceptions about people about criminality or about crime. However, we are here to get educated and for you to understand what are the limitations, what can make you become criminally liable. But first, let's have our news details, which is so legal. And for this episode, our legal news will be taking of incidents which occurred in India, in which a law was passed based on citizenship in December 2019 that was actually discriminating to Muslims, and because of that, all this back, citizens have been fighting and protesting for the eradication of such law. Let's just take a look. Law is ignorantia legis neminem excusat, which means ignorance of the law is no excuse. Some of us do appreciate such legal expression, while others do not, on the basis of fairness and unfairness.
India's Prime Minister Narendra Modi has appealed for calm after days of clashes between Hindus and Muslims in New Delhi. At least 20 people have been killed, and there are now calls from Delhi's chief minister for a curfew.
The protest began as a demonstration against Mr. Modi's new citizenship law, but quickly deteriorated into battles between armed mobs. Arson attacks and looting have been reported.
At least 2 mosques have been set on fire. Nearly 200 people have been injured, about a third have gunshot wounds.
And our correspondent Ishan Garg has the latest from New Delhi right now. So Ishan, is this curfew likely to happen right now?
Yes, as a matter of fact, the Home Ministry, the federal government, has imposed curfew at the very epicenter of where the protests broke out, and the violence has been continuing for the past 3 days. So a complete lockdown of that area has been initiated by the federal government at the central level. But apart from that, there is a partial curfew. There is a section 144 of the Indian Constitution which prevents large public gatherings. That has been imposed in a number of areas which are believed to be sensitive as far as communal tensions are concerned. So you have areas where the Shaheen Bagh protests had happened over 50 to 60 days, where protesters had continued to sit in for more than 2 to 3 months. And there are nearby areas of, for example, Jamia Millia Islamic University, which has again been a hotbed of anti-citizenship amendment law protests. So these are areas where police are taking special precautions But as far as curfew is concerned, the complete lockdown of the area is concerned, it's only happening in that one specific area where violence broke out 3 days ago.
Ishan, given the deaths, at least to 20 people as we understand it, has the government come under fire for its response?
Certainly, the government is receiving a lot of flack from international media organizations, from opposition parties, even from people on social media. Everybody is questioning Prime Minister Modi himself, saying that while Delhi was burning 2 days ago, he was enjoying his visit of President Trump. They were exchanging hugs. He was given a ceremonial treatment at Rashtrapati Bhavan, the President's house in New Delhi. All of this was happening while a part of New Delhi was burning under communal tensions. The government has come under a lot of fire, but it has also deployed some of its highest bureaucrats. The National Security Advisor himself is on the ground in New Delhi. He is taking a stock of the situation of how things are going, and the Home Minister and the Prime Minister, both of them have tweeted, they have spoken out against the violence. They have said that they have been coordinating with the Delhi police and that peace will be restored very shortly in New Delhi.
All right, many thanks for that. Ishan Garg speaking to us from New Delhi.
One of the most famous Latin legal presumptions of law is ignorantia legis neminem excusat, which means ignorance of the law is no excuse. Some of us do appreciate such legal expression, while others do not, on the basis of fairness and unfairness, justness and unjustness, morality and immorality. Whether you know the law or you do not, you are part of the law, because the law is made for you and you must know the law. Thus we bring you the legal hour. Actus nemini facit injuria. The act of the law does no one wrong, but uphold justice. Welcome back to the show Legal Hour here on Freetown Television Network, 35 with me, Abubakar Malam. Well, that was a short incident that took place 4 days back at New Delhi, in which citizens protested against the law that was discriminating against the Muslims when it comes to citizenship. And back to our guest for today's episode, who is Mr. Victor Tutu Rogers, a paralegal at the Legal Aid Board, and at the same time a human rights civil activist. So before we come to our topic on responsibility, I want first to throw light on what just happened in New Delhi.
I think we're talking about, we're coming to talk on the criminal responsibility. But we're starting with an area of the right to an individual. We are in what took place just now that we rightly saw in India is rightly boiling around the Universal Declaration of Human Rights. Wherein you have that right to belong. You think of religion. A religion is a choice of somebody to belong. And if you have the right to belong to an association or whatsoever, then your liking is being discouraged because of another man's own liking. There starts the violation. That's a clear manifestation of a human rights violation, discrimination, trying to say that the Muslims is like they are not human, because these are all human for whatever institution you belong. Who belongs to that institution is human. And if it is a human belonging to a particular denomination as his or her own religion, then is being discriminated. It's a complete human rights violation. So when you look at this particular act done in India, clearly testifies, one, their choice of religion, meaning they have religion that do operates in their country. That's what they want to establish. And if not, then they have been a Muslim before. Then why discriminate the Muslim to like sideline them, marginalize them, send them off as if they are not human? It's a clear manifestation of it. And you can see the protest along the line. Looking at the protest very closely, you see what marginalization causes: destruction, damages. retrogression, sending the country backward in regards to development, because the malice that is created around being marginalizing somebody from his or her own comfort.
Right. Yeah, of course. Yeah, I actually give adherence towards your proposition, but let's say now, basically, they are giving citizenship to neighboring countries, those who actually found their way into New Delhi. But if perhaps because these are not original members or citizens of
India,
New Delhi by origin, but however they are neighboring immigrants who found their way into New Delhi. So if they choose to give a certain standard of citizenship to a particular people and then they marginalize the Muslims, I think that is not a violation of the human rights, because they are not per se original citizens in New Delhi.
if you have been very well when I was saying that unless if they are not part, it is not part of their country religion, wherein the Muslim is not part of their denomination or religion aspect, then it's like a new religion coming into their country, which they may want to kick out. And if it is so, then must be clearly established during the time of their citizenship, getting them into their country to what are the laws binding. And because when we look at Sierra Leone right now, what are we seeing every day? That people just come into Sierra Leone and go out like that. But in other countries, when you want to get there legally, you are legally recognized through documentation. And during that documentation, what are the inputs and the documentation? But because what is documented there is what you abide to when you are living in the country.
Yeah,
so we look at the documentation.
It's also a different topic. It's like a gross violation of human rights, which will be a very vast topic to discuss.
So it depends how the documentation was done for them. There was nothing like which denomination you have to belong when you come into our country, or you come and yield to what we have, not on the implementation. Because we've got some similar instance wherein in Sierra Leone there came a time wherein this naked, there was a religion that I wanted to establish here, born naked. Born naked. Born naked was not agreed to by Sierra Leoneans, because we look at it, the moral aspect, that it is very much indecent, and because it is indecent, Sierra Leoneans, we are not ready to accept it, though it might have been a religion, but practice elsewhere that they accept. Sierra Leone is not part of our culture. Because it was not part of our culture, I will look at it to be very indecent, and that will divert the minds of people to get into another different style of living. We kicked against it.
Of course,
where at the U building, a number of people entered into the U building where they were doing their ceremonies, and we are attacked, physically attacked, to get them not any establishment at all. And at the end of the day, within few days, it went off. So what we don't say there, we don't say that we too violated their rights. So that's why I said it's based on your documentation upon your entry as to how each constitution
is also a signatory to the UDFI and also the ICPR, and ICPR also actually guarantees the right to conscience, which also in our constitution section 24 also guarantees that. But that would be a vast topic to discuss. So let's go.
That's the area I wanted to come again. It depends on the constitution of the country. That's the Bible.
Of course,
yeah. And in that Bible, if it is in there, then you go according to how it is written in there and how it was accepted. If it goes off that acceptance, then your whatever initiative you have will not be comfortable within the environment.
How are you on Freetown Television Network with me, Abubakar Malam? The issue of human rights violation will be so vast to discuss right now, so let's get back to our original topic, which is criminal responsibility. Now time to ask the questions. Am I too small to be criminally liable? Am I too big? Am I too old? Who am I? Am I above the law? We're here to know and to get educated the more. So let's start with our topic, criminal responsibility. Yes, Mr. Rogers, we've talked a little bit today, which was very much sensible about the human rights violation that took place in New Delhi. So now to our topic, criminal responsibility. What is your own take?
Well, looking at the word criminal responsibility, the word criminal of itself is that level at which you highly use your intelligence to exploit the other for your own gain, right? Using high intelligence, where you know that what you will be taking from the opponent, will be of a detriment to that particular person. Using your intelligence to profit from the person in a way where he or she will not be aware of it at all, to only know later that to him or her is a loss or a lose.
Okay.
That,
of course, I tend to get your definition of criminal responsibility, but first, criminal responsibility is like it's.
No, I'm just talking about
the crime. Yeah.
Yes.
So let's get to get the concept about crime. What is crime out there? If it's something you do to your colleagues or something you just do with society, what's crime? Crime.
Crime. You look at crime as like an act. A crime is like an act done to another person that hinders the life or the future or the resources or whatsoever within the circumference of that particular person, as against your wish for your comfort.
Okay.
And having committed that crime that will cause harm to that particular opponent, give cause for a report as against you for an action, like to replace what you've used your high intelligence to take from me when it is not to my consent. Again?
Is it like let's say when you've done something wrong to your colleague or to somebody that could be a human being, let's say a damage, an injury, that could be result to death. That could be a crime also.
Yeah.
So if you look at crime at this particular concept, what about in a scenario where let's say we get into a business and we've agreed on the terms of the business, and then let's say you are to supply me 10 bags of rice and I am to give you 10 billion loans. Now you've actually supplied the rice to me, and then for me to pay my own obligation, I fail, and that results to an injury, or let's say to damage, or it might affect you one way.
Yes.
So those
the impact
could be actually given as a crime.
If you look at it, it's a crime. We've agreed on something. I've played my own role. I've satisfied you, and in return you are to do the same.
Okay.
And having got it in mind now that I will benefit from what you two have benefited from me, and later resulted for me to be the loser, instead of gaining from what I should have, become the lost. If I'm not pleased, because it's like an injury, there's an effect for which I too may want to satisfy that effect. In satisfying that effect is to bring you to the law. Because I may not want to take the law into my hands. There are special institutions responsible for that. I'll take you there because I've satisfied my own part for satisfaction, and in return you have failed to satisfy my own portion from you. Okay. So automatically it's like an injury to my comfort. So it's a crime. So now you put it in another way, the commercial form, wherein I will talk about the physical or bodily harm. It depends the crime as to how it comes, because like a criminal responsibility, it goes this way. It can be a process of a crime scene, something that will happen, where the process, the performing scene, how it happens, how actually it took place, And then you look at the recognition of the scene of crime.
Okay.
And what will be the aftermath.
Okay.
So the response to that, and getting a report, looking at the documentation area, for me to go and make a report against you for a transaction we've entered into, I've satisfied your own part and feel it to satisfy my own part. I will not want to take the law into my own hands to stand and fight, and I become more. So I take the law to the appropriate institution for a redress. And taking that law to a particular institution for a redress works alongside as to how the law is work on as to how we should give back what I have, or a punishable or kind of there will be a punishment for that. Yes,
imprisonment, a fine.
That's it. So crime depends the way how it happens.
So let's say crime gives rise to criminal law.
Yeah.
So it's one to say crime is an act which is wrong and that is injurious to the rights of others, that is done against the state or that is done against
an individual. Yeah.
Which one are we to choose? Against the state or individuals?
Well, against the state, it's like against all. Because when you commit a crime against the state, and the state has a constitutional mandate for which if you go against it, you'll be dealt with according to the law. It's the same as if you commit a crime against an individual for which it has its own jurisdiction also as to how they dispense the law accordingly based on the crime. So a crime against the state is against all. You've committed a crime against the government, and the government is who? It's you and I. And who is you and I? It's you and I that agreed on a particular law for us to be governed by. So because having the parliament where we have our law people to make the law, representatives from our constituencies for which they represent each and individual in that constituent through their parliamentarian, and the parliamentarians are in the house there to make the law, and at the end of the day they agree to on the laws prepared on our behalf based on our agreement. Then if you fall against the state, it's against all. A law that we agreed on is what you violated, and if you violate that law, there's a punishment placed there to go by if violated. So
at least regulates the conduct of humans against, of course, our humans.
Yeah, to check and balance your attitudes and behaviors as to how you should live in a community.
Yeah, definitely. Yeah. So I believe to some extent we have actually understood what is crime and also criminal law at the same time. But now we are actually now going to dive into our topic, criminal responsibility. So now if we have understood what is crime and how one can commit an act which can be seen as a crime, we have what we call criminal responsibility. In other words, if this is what you've committed and it has been seen as a crime, what can make you responsible? Because I believe that the law has certain standards that it is looking for. Even though if an act is being committed, these standards can be put in place to at least use as a mechanism to assure whether the act is a crime or it is not. And if it is a crime, how can one be punishable or be responsible for such a wrongful act that a particular person had done?
Very good. I think I highlighted few when I spoke of a process crime scene, the area of responsibility, having committed a crime, how to know that this crime was committed, how comes the crime. The first thing about the crime is the process, how it happens. The crime scene, you go to the scene, there is a death that occurred in place and somebody stabbed by who. So you first visit the scene of crime, how it happens. You go through it, and as you look at the performing process as to how it actually happened, who are involved, or who is involved, or who are at the scene when it happens. The responsibility, because for you to become a responsible, they haven't been, if caught as a suspect, what makes you become a suspect? And until when witnesses will come on board to say you committed a crime, they saw you for any further documentation or whatsoever, how will you be responsible now? The responsibility now is operate within the application of the law. The
level of the discussion.
Yeah,
you did say if somebody has actually been suspected of committing a crime, until the law has to come in and then says you actually committed a crime.
Yes.
But let me say, if somebody has committed a crime which will be seen as a felony so severe, can any person, or let's say a private person, has the right to arrest such person based on a suspicious standard?
An individual?
Yes, a private person, not a police officer, not a public officer, not a court, just a private person. Now, for example, you have done something wrong, and I actually noticed that you might have done something wrong, but I haven't gotten a confirmed source of that, and based on that suspicious standard, I arrested you.
You arrest me based on the crime scene.
What if there are, I might have seen the crime scene, but rather I have no
very well
evidence that you did the act. So as a private person, you have the right to arrest you.
A private person?
Yeah.
You can only arrest one if it is a place where you have it like a hard to reach area, where you don't have police presence, right? A distance of a police from the crime. Having a police station very far off from the scene of crime, and this scene of crime, there are substantial evidences, though private, but actually know that you did the act, and leaving you to go, you escape and leave the particular case like that. So if you are in any way of attempt to escape, and you are a private person, and if this particular person escape, there will be no way to have a headway on that particular matter. If you are physically strong to arrest that person at that time, at that moment, you have a right to arrest. As a civilian has a right to arrest based on the scene of crime, when police presence are not there. But in the situation is the area of to detain the particular person. I think just after the arrest, we must quickly try to reach a police presence, either to the police station, take the person to the police station, or invite a police to come to the scene, so that the police now who has the responsibility to arrest.
So for one to be responsible for an act done which could be seen as a crime, I do believe, from what I've taught previously, that there are two elements looking for. That is the mental element and the action itself.
Yes.
Okay? So if one does an action that could be seen as a crime, but there is no intention of doing that, or there is no mental element that gives support to other particular acts, could one be responsible for such an act to be seen as a crime?
Talking about the area of element, the mental area of it, that can be done through the court of law to see how best that will work based on the presentation of the matter.
So what if the court finds out that there are no intention or there are no mental elements for the act which was done and be seen as a crime? Could that person still be guilty?
Based on the process.
How? Please justify.
In court, when you're in court, you are criminally accused of a crime. Then you are taken to court with your different presentations you are doing right now. It's based on how the matter is presented before the court, and the legality area of those that are legally inclined will look at it and use their discretion based on the matter and line in conformity with the law. So in that area, it's like a naked post-mortem we are doing now.
Okay.
But if it is before the court now, being legally minded will know what exactly they will do based on the matter, the presentation of the matter. People have, you and I have seen some cases within our environment which you can give a quick judgment for.
Yeah.
But we've seen those matters taken to court with different judgment. It's based on the matter and who attends attends to the matter. If you have a matter, the law is as good as itself, right?
It's as good as its word
Itself.
itself. Okay.
Yeah. When the law is there, you may have a good lawyer. You may have a perfect lawyer, but the case is the case, right? The case is of itself. It's based on argument or whatsoever. But when the fact is there, it is there. It's not left to the lawyers fighting the case. You know, the law is like a mathematics, right? It's -1 + 1.
Okay. Lest I forget, you did say, if such a person has done an act which is described as, let's say, which has been described as a crime, okay, and then the person did not have the benzia, that is the mental element to do the action, you did say the court has to use its discretion, or perhaps the judges or the judge that is doing such a case has to use his or her discretion to at least decide for whether such a person had the intention or the mental element or not. Okay. Now this actually
it happens so
presumes that
that's what I'm saying.
Of course, yeah,
it based on the presentation.
Step on.
Yes.
But it actually it's presumed as if the judges rules based on rule based on discretion, not the law. So if that's the case, that the rule on discretion that might not even be in the confines of the law, it's like it could be very hard to say.
No. Maybe you never got the conclusion of my statement. I said it's left to the lawyer to his or her discretion based on the law, conformity with the law, because the presentation of the matter, presenting yourself. There are some cases where it's the way you present it. As before this time, I have initially told you that we've seen some matters in our naked eye, so we see it to have a quick judgment to it because of we saw what happened. Okay. But when it goes to court,
let's say what's in a situation
based on the evidence,
the person stands now holding a knife, perhaps let's say plucking an orange, and then somebody else comes around that particular scenario and then grab the knife, and then they actually begin to wrestle and doing other stuff, and then mistakenly the person that was holding the knife previously or prior to the occasion or the incident stabs another person. The person that holds the knife and stabs the other person as a result of the other person who actually wrestles with him, will that person be criminally liable for stabbing, which will lead to the death of the other person? Whether it was manslaughter or perhaps one could easily decide to say it's murder, but it depends on how the scenario or the incident.
The scenario and the intention. It's based on the scenario or the intention. I don't have a knife.
Yeah.
I'm working with it.
Of course,
Then you come and grab it. Then they start to look at what was the intention before coming to.
So in that case, you never had the intention, not so, to stab somebody.
You never had.
Of course, the person who owned the knife never had intention.
No, not at all. You are using the knife. Yeah. With no intention to come and stab anyone.
Of course, somebody's act.
An attack is like an attack.
Well, it could be an attack here.
It's like an attack. I'm holding a knife, which is poisonous, dangerous. You know very well you are a human. You know that holding the knife for you to come and grab it can be dangerous.
And then you stab that person and
can be dangerous.
That is okay. So now you have no intention to kill.
No intention.
However, the acts of a sin to be done by you.
Yes.
So now taken to court, are you criminally responsible for such an act which is seen as a crime or not?
Well, at the initial stage, for a documentation like an kind of investigation, we are making a statement. At the initial stage, for a statement to be documented for court action, I don't know, they take you to the criminal, you will be responsible. Yes, exactly, but until the court will find you now guilty or not. But at that initial stage, they will claim you must have killed the person because you were holding, and you ask, who was holding the knife? When the know-how is not there, the legal know-how is not there, that's the question that we don't, who was holding the knife? So you are the one that killed the person. But until they go no further investigation, and we are the scene. And how did the wrestle go on? Who started it? Who came and grabbed the knife? What led to that? So prior to your explanation, while you are explaining, these people are people of wisdom. Is there, they will start to know, to diagnose the incident that took place and come out with a result. So all is depend on the matter and the presentation. Some people might have a very good case, but they don't know how to present it. We've seen files thrown out of court because it's of facts, but the preparation of the document was not done according to the way how it should be presented before the court, and that matter is thrown out of court. Have you not seen that? So it all is based on the presentation of the matter and who stands to defend you. Because in court, a lawyer knows very well that you are wrong, and he comes and stands for you. How many times I will not say, a lawyer, why go and stand for SP case? Me very well is a person, I mean a crime that is that kind of fierce, right? But you go and stand for it. Me very well. What happened? You go and stand for it. But in the court now, fighting for each other, the lawyer defending his client as against the other. At the end of the day, it's based on your mistake. If automatically based on your mistake or your presentation, the loser comes up based on his own presentation. So it depends on the presentation.
Of course, yeah. This is Legal Hour here on Freetown Television Network with me, Abubakar Mara, and our topic for today's edition is criminal responsibility, and we have discussed the depth of such topic on floor right now, and we are about to understand that criminal responsibility, you must have two elements, that is the intention, and also the act itself.
Yes.
And with me have been having Mr. Victor Tutu Rogers, a paralegal at the Legal Aid Board, and also a civil activist. Yeah, let's go for a short break and then come back for the conclusion of our topic on floor. One of the most famous Latin legal presumptions of law is ignorantia legis.
I am the judge, and it's my job to interpret and uphold the law. Other people present during a trial at the Crown Court are the prosecution barrister and the defence barrister, usually with solicitors behind them taking notes, and the jury. The defendant will sit in the dock and be present during the trial. It is at my discretion whether or not there is a public gallery. After the jury has been sworn in, I address them directly. I inform them that it is for them to decide if the evidence they are going to hear proves the defendant's guilt. I also inform them that it is their job to consider the evidence, not the law, and that I will guide them if necessary on points of law.
I am the next person to address the jury. I introduce myself and explain that I appear on behalf of the prosecution in this case, and my learned friend, who I name, appears on behalf of the defence. I then outline the prosecution case, explaining each offence and the evidence the jury will hear in proving this. I will state that it is the prosecution's responsibility to prove beyond any reasonable doubt that the defendant is guilty of the offence that they are before the court for. I will introduce the first prosecution witness. I will then ask a series of questions with regards to the evidence they have given in a statement to the police. This is known as examination in chief. Upon completion of this, the defence may ask the witness a series of questions. This is known as cross-examination. Upon completion of the cross-examination, I may be given the opportunity to ask a further series of questions to the witness. This is known as re-examination. I will continue to call witnesses until all the witnesses have been called to the stand. I will announce to the court that this is the case for the prosecution.
at this point in the case, I may make an application of no case to answer to the judge, stating that the prosecution has
back to Legal Hour here on Freetown Television Network, 35 with Mama Kamara. The time is against us and we are about to close to this edition, so let's have the final statement of our guest, who is Mr. Victor Tutu Rogers, a paralegal at the Legal Aid Board and a civil activist. What will be your last statement towards everything that we've discussed?
Well, my last statement will be in summary about the criminal responsibility, wherein a person's ability to understand his or her conduct at the time a crime is committed. So if you know at the time when the crime is committed, then you know you are liably responsible for a crime. And I will look at ages more for children criminally liable. You look at ranges from 6 to 12, a minimum of 7 years, and from there now upwards you look at crime to be liable. But it depends again the country. Some countries have based on the age limit, but from 6 to 12 or 7 minimum. And so looking at all these things, criminal issues wherein it must be educative, and it will be nice for legal institutions to be coming up to be educating the public on criminal responsibilities. Having that on stage, I think that will at least reduce the crime rate for which we are almost always involved.
Mr. Victor Rogers from the Legal Anybody Paralegal. It's been nice having you in our studio, and we hope to have you again in our subsequent programs. Well, viewers, thank you very much for being part of us. This is Legal Hour here on Freetown Television Network, and this is how we come to the end of today's edition. I've been the presenter, Abuba Kamara, and many thanks to our producer, Laptop. Thank you very much. Till we meet for next episode. One of the most famous Latin legal presumptions of law is ignorantia legis neminem excusat, which means ignorance of the law is no excuse. Some of us do appreciate such legal expression, while others do not, on the basis of fairness and unfairness, justness and unjustness, morality and immorality. Whether you know the law or you do not, you are part of the law, because the law is made for you and you must know the law. Thus we bring you the Legal Hour. Actus nemini facit injuria. The act of the law does no one wrong, but uphold justice. One of the most famous Latin legal presumptions of law is ignorantia legis neminem excusat, which means ignorance of the law is no excuse. Some of us